Top 5 things to do when charged with sexual assault.
This is very important because when people are charged with sexual assault, they rarely see it coming. And it's very important.
That's absolutely true.
It's very important to understand.
I've never had a client come in and go, I was expecting this.
I know, right? and because you're not expecting it, like, people are stunned, and most people have never actually been arrested for anything in their life before. And so it's a shocking experience, and it's like a total different world, which, of course, the very first thing when you're being charged is you need legal advice.
Why is legal advice important? Let's say the police call and say, excuse me, Mr. X, we're investigating you for a sexual assault. We'd like you to come down to our station to have a talk with us. What's the first thing you need to do?
Beyond that, we've seen, because they can be very clever, they say, like, we understand, you seem like a nice guy. There's always two sides to a story. I'm pretty sure, like, it must be terrible to be accused of this thing. I'm sure you wanted to let us know.
So that's their invitation.
What your side of the story is.
That's their invitation to come down to the police station if they don't come and arrest you.
And they make it sound like they're friendly. Sometimes, not always.
Not always, but sometimes they do, because they want you to talk to them, and giving a statement is a bad thing. So the first thing you have to realize...
Do the police actually want to help you get your side of the story?
No. Rarely. Once in a blue moon, I've had it where the police actually wanted to speak to them to try and figure things out. But that's literally in 3 cases in 31 years.
But what I have seen is this is one of the best ways. We've seen clients that have said, I don't want to give a statement. I've been advised not to give a statement, which is their right. There's nothing wrong with refusing to give a statement. But
no, it's the right thing to do.
When I see them give in, even though they've asserted numerous times they don't want to give a statement, when they give in, it's usually because an officer says to them, I know you probably didn't do this, and I just want to hear your side of the story.
Right. So let's say number one. Number one, realize the seriousness of the charge and that you need a lawyer who is familiar and experienced with this type of charge so that you can get proper advice. That's number one. So we're talking about this.
The police primarily are looking to lay a charge. They're not looking to vindicate you. The police are primarily looking to lay a charge.
Right. So you have to realize the police are going to lay a charge, regardless of what you're going to tell them. So you need to understand that an allegation of sexual assault is extremely serious. The police are not on your side. They're not looking for evidence for you to be exculpated from the case. They're looking for inculpatory evidence, okay? And like spelunking. And you desperately need legal advice right away. So the first thing is realize it's serious. Try and contact a lawyer who has experience with this type of case.
But at the time you're charged, especially if you don't have advance warning to turn yourself in or whatever, it's like you'll normally just be given a line to, the first lawyer who answers the phone on a...
Well, no. First of all, in Canada, you read your rights to counsel, and you have a right to choose your own counsel. So if you happen to know somebody, you have a right to try and speak to that person. If you don't, you can be given an opportunity to take a look at a list of lawyers if you want to call somebody who's an independent lawyer. If not, then you have the right to call duty counsel. Mm-hmm. Okay? Yeah. Either way, you're going to get legal advice, which will tell you don't give a statement to police.
And there's a reason why.
There's a billion reasons why. Don't give a statement to police. This is not poker. You will, once the process is ongoing, you will get the disclosure. You will know the case against you. And at a later time, of course, you can testify. But once you give a statement to police, it's very hard to take that back unless your charter rights were breached or you were somehow oppressed by the police to give a statement, so it wasn't voluntary. If you give a statement, you're going to be boxed in. Do not give a statement, period. But it's extremely important to then embark, once you are charged, to try and find a lawyer who knows what they're doing. And you're looking for experience, somebody who's very familiar with this area of the law. Even though all criminal lawyers do all sorts of charges, lawyers specialize. They're like other professionals in medicine, for example, where you're a tertiary specialist and you may do hearts and neurologists, whatever. Criminal lawyers also specialize. So I think in this area of law, it's extremely important to look for a lawyer who has extensive experience in defending sexual assault cases.
Yeah, and also when you're being asked to give a statement, the police don't have an obligation to tell you all the facts of the case, and
They can lie to you.
they can lie to you. So one of the reasons you don't want to give a statement up front is that you need to have disclosure. You need to know what the actual allegation is before you try to respond to it.
Yeah, it's
so
like
important.
anything in life. If you want to make a decision about, an apartment to rent, a house to buy, an investment to make, or where to go to school, you're going to research everything, right? You're going to research and get as much information as possible so you can make an informed decision. Well, you're entitled to know everything there is about your case before you say anything about it, so you can make an informed statement about it. When you go into the police station and you're just traumatized at that point about being charged, you're not in your best situation or your best position to give a statement.
Yeah, which leads into point number 2, and that is you want to document as much as you can once you know what you're accused of. But you can't document what you're accused of, things that are relevant to what you're accused of until you know precisely what the allegation is.
So you can start, and you can start making notes about, you'll probably find out for sure who the complainant is, so you may have some ideas. The police may disclose certain facts that might ring a bell. So you can start documenting some sort of history about what's involved in the matter, but that won't get completed. And typically, we speak with clients and we ask them to start a chronology, which is a historical outline of everything with the complainant from start to arrest, and we ask them not to complete it until they've read all the disclosure.
Right. And that's so important, because you can waste a lot of time focusing on things that are irrelevant unless you know precisely what the allegations are. And, until they've actually seen the full allegation, they could end up saying a whole bunch of stuff or focusing on things that are completely irrelevant. And the focus is one of the trickiest things I think we experience with our clients, because they get caught up in other details that are emotional to them. And you need to be focused on the actual facts of the specifics of the allegation.
So number 2 is start documenting, but that won't get completed until you have reviewed the disclosure and had some direction from your lawyer about what they may be looking for from you. But try and err on the side of giving as much detail as possible, because what a client thinks may be relevant or not relevant may be different to the lawyer. Often we get information they may think is not relevant, we think is relevant. Also, gather up any messages or communications or pictures or anything you have as source material about your connection and communications with the complainant. Start saving them.
Just to slow it down a little bit. Just slow it down. Explain that. Disclosure. What's disclosure?
So in Canada, we call it disclosure. So that means that the government has to disclose all of the evidence that they intend to rely upon in the prosecution of the case. So that would be primarily the statement of the complainant, which will be on video. Could be witness statements, medical records, sexual assault kit, if it's applicable, any other evidence like biological evidence, toxicology, police officers' notes. Everything that the Crown has gathered from the police as part of the ongoing investigation must be given over to the defense. And it's very important. We take the statement of the complainant, we have it transcribed so that we give a transcript to the client so that they can review that transcript and they'll know everything there is about the case.
So sometimes we have cases where people are concerned that the prosecutor might come up with some sort of a message going into trial that we've not had disclosed to us. And so they get a little paranoid about, this or that or whatever. Disclosure has to be given in advance to trial, and the prosecutor generally can't just produce new evidence at trial, right?
No, so that's actually a very good point. So in any criminal case, the investigation can continue up to trial and even during trial, okay? But 90% of the time, you will receive everything up front even before you set the date for trial. But there can be occasions where an investigation is ongoing. Typically in sexual assault cases, that investigation has typically come to an end at the time that you're getting full disclosure. But in certain instances, there may be a witness who comes out later on or some other or because of disclosure of messages or some other things that there could be ongoing investigation. But most of the time, it's fully disclosed. If something does come up on the eve of trial or during a trial, that can result in a number of things. One, it can result in an adjournment of the trial or maybe even a mistrial. So, the prosecution is generally desirous of getting all of the material to the defense prior to trial so that there can be a smooth process in place for the trial without any interruptions or without a mistrial.
This kind of brings something to mind that we've had to explain to people in terms of explaining the process as well. The prosecutor is going to call their case for the against the accused. They'll call their witnesses. Their witnesses will then be cross-examined, and then the Crown will close their case. Once the Crown has closed their case, the defense decides whether or not they need to call evidence. Usually we do. And can the Crown then call another witness?
In reply. So when the Crown closes their case, the idea is that all of the available evidence that was necessary for their prosecution has been called. And then you call your own defense. And then sometimes, if something new arises from that, there is the chance in a very limited way for the Crown to call reply evidence.
Rebuttal evidence, basically.
It can be rebuttal. We call it properly reply evidence in Canada, but it will be to rebut or address something raised by the accused or other evidence. And so that's something you have to be aware of. Again, in sexual assault cases, that's a rarity, but on occasion that can happen. So you want to make sure that when you're calling evidence at a trial, that you understand the full breadth of that evidence and its impact, and you've done enough work with your client and through other means that you know there's nothing out there that could cause a problem for you. So you got to be careful about that. But in the vast amount of sexual assault cases we've defended, I've had reply evidence 2 or 3 times, and when they've called reply evidence, it's backfired.
Yeah, I just realized we're only on number 3. So number 3, learn about consent in sexual assault charges. You have to understand what is consent, what constitutes sexual assault, and so they can understand what it is or is not helpful in defending their case.
So that's a really good point, because I think this is a process with the lawyer, and we try and educate our clients about the area of sexual assault, because the more educated the client is about consent and what constitutes a sexual assault, the better they'll be able to focus, the better a witness they'll make at trial. And so often we'll give them case law, or we'll give them memorandums. We do a case analysis, and we do sometimes a memorandum of law, depending upon what particular facts there are, so that the client has as much available information to understand the case against them. And that's educating them also about sexual assault law.
Well, there's a lot of misinformation out there in social media and such that kind of makes it look like you need to have verbal consent for sexual interactions, when in fact, in Canada, at least, it's still the case that that consent could be communicated through actions as well as through words.
Right.
And it's important for people to be able to articulate why it is they thought they had consent. And this seems like something that should be a no-brainer, but it's not actually, because the reality is human beings have sexual interactions in ways that it seems natural and fluid the way it's taking place. But then when you have to break it down, it seems so unnatural to break it down. Right.
So having that understanding is helpful. And you can think of other areas like capacity consent. We reviewed that in a podcast recently where, we go over and did a refresher on what capacity consent is. Because in cases where there's alcohol or drugs involved, the issue of whether a complainant had the capacity to provide consent is an issue. The client getting educated about that is extremely important, because then we can tease out from them other relevant evidence, not only from them, but maybe from other witnesses. Mm-hmm. But understanding that concept is very important, because often somebody can say to us, well, I was drunk too. That's great. That doesn't help you.
No.
So giving them the education and having a client take the time with the assistance of a lawyer to learn about consent, cases where capacity is an issue, learn about that.
How to explain the way consent was communicated. It seems like it should be simple, but
it's not.
In reality, it's not, because you have to go back and be like, like I said, it is fluid. And so the fact that an accused person is going to have to articulate specific things, and then they're going to be questioned about why they remember the specific things.
All of this factors into ultimately what will happen at trial is that an accused will eventually testify. We've said it a million times. In order to win a sexual assault case, 99% of the time you've got to testify. The accused has to testify.
Otherwise, it's just she said. There's no he said.
That's right. And the client will have to be able to give specific details about why they believe they had communicated consent. And so understanding these concepts is vital to mounting a proper defense.
And that leads into point number 4, which is understand the way the courts operate and what is evidence. And we've talked about
done
this
that
a
few
number
times,
of times. Well, how can I be charged when there's no evidence? And the reality is testimony is evidence.
The statement of a complainant is sufficient for the police to have reasonable probable grounds to lay a charge. Testimony at trial is capable of being believed by a judge beyond a reasonable doubt. Period.
You can be charged and you can be convicted based on nothing more than a complainant making a statement that a certain thing happened.
Well, testifying at trial.
That testimony at trial is considered, well, and sometimes their police statement will be put in substitute for evidence if they give a statement and they're a young person.
Well, it's not substituted. So if you're dealing with somebody who's under 18 years of age, it will go in for the evidence in chief. So under 715.1, the Crown can put in, in Canada, the Crown can put in the actual statement of the young person, the young complainant, into evidence, but they're still subject to cross-examination.
They're still subject, yeah. So in that case, their statement can be played into evidence, so they don't have to actually recount everything, and then they're asked, follow-up questions and then cross-examined on the things. But they're asked, do you remember giving that statement? Yes, I do. And do you still say that's true? Yes, I do.
Yeah, so this is really important because understanding how the court operates and what is evidence is vital to being able to defend yourself. And we try and give real education and training on testifying in a court and understanding the court process, because that will make a person a far better witness. So this is an extremely important point. Understand how the courts operate and what constitutes evidence. Vital. Number 5.
So number 5 is understand that when you testify, your job is to answer questions, not to ask them.
Yeah, so that encompasses more than just that. So testimony of an accused is a vital aspect of a defense. Sometimes it's everything. An accused has to be able to communicate to the court their evidence in an effective, emotive way so the court can then give weight to that evidence. Even if they don't completely believe it, it can raise a reasonable doubt. And it's very important to learn how to be an effective witness. We often say it's hard, but try and transcend you being the accused to just being a witness and giving the evidence over. Very hard, but with training and time, it can happen. You're not there to, ask the Crown, the prosecutor, a question. You took advantage of her when she was drunk. You brought her to your room and you definitely sexually assaulted her because she was drunk. Why would I ever do that? Well, that's not the right way to respond. You don't ask a question. You answer the question. It's vital that you make eye contact with whoever's asking you questions and you answer the question. Mm-hmm. Don't be evasive. Don't ramble. Answer the question. When a prosecutor is finished asking the question and you answer it and then there's a pause because the prosecutor is gearing up for the next question, do not fill the air with your voice. Just answer the questions you're being asked.
And it's very difficult for people because, especially going into trial, they're used to talking to their lawyer who's their advocate, and they're not used to being accused of something point blank. And it can be very disturbing for them. And you have to keep your cool and just listen to and answer the question.
Yeah, you have to walk a careful balance between being polite and respectful, but assertive enough to get across to the court your innocence. And, I try and say to clients, you understand the concept, you're innocent, okay? So you need to communicate this. And in some instances, of course, people have different personalities, and they're going to testify in accordance sometimes with their personalities. And some people may get quite passionate about it and say, I didn't do this, and get a little emotional. That's fine. Just don't do it to the extent that it's going to detract from your credibility and reliability. But you have to understand...
Combative. I've learned to say that word properly now.
Well, I say combative. Don't be combative.
Combative is how I like to say it.
Don't be evasive.
I've come to learn that's wrong.
But understand that balance between being respectful and polite and being assertive in what your position is. And understand your evidence and get it across. And don't be scared about cross-examination, because cross-examination is a wonderful opportunity to be able to get your evidence out again.
That's a great point, because this is one of the things that I say to people, you say to them as well. Don't be afraid. This is your chance to get your story on the record. And for most people, they have to be in silence once they're charged. They can't say anything. They can't communicate. They're told not to talk about it. This is actually their chance to actually get their story on the record. And you don't do it when the police ask you to do it up front, because they're not your friend. You do it at the right time, and focus on the things important. Just say what you know. Listen to the questions. Be responsive.
This is now the opportunity where you're going to be in front of a judge or a judge and jury and be able to talk about why you're not guilty. And it is your opportunity to get that across, and you have to try, and as nervous as the person will be and as difficult as it will be, to try and embrace this opportunity, because it is very, very important to give that evidence. And we say this very carefully. It is rare that an accused in a sexual assault case should not testify. It is rare. And it's not a decision that can be made lightly. That has to be discussed with your lawyer prior to trial and during trial, and it has to be on a very informed basis, because the ramifications of not getting your evidence out before a court can be absolutely devastating. If you appeal, a court of appeal can take into account the fact that you did not testify. And so there are significant deficits to not testifying at your own trial, especially in a sexual assault case.
It is scary. We've seen people who are totally confident because they're just saying, oh, I have no problem. A secondary witness even ends up finding themselves shaking when they're on the stand, because you're not used to being in that environment. You've got a person sitting on a pedestal right next to you who can put you in jail for the rest of your life if they want to sometimes. It's very scary. And so people get there and they think they're totally ready, and then they just they start shaking and their throat dries up or whatever. It's it's difficult. You just need to.
But that's okay. I mean, I try and communicate to people, it's okay. And often if we see a client whose hand is shaking and they're choking up, we'll draw it to the court's attention. Are you okay? And the person should say, no, I'm sorry, this is really difficult. And often one of the ending questions I will ask is, how has this charge affected you? You will always hear a prosecutor, or a lot of the time you'll hear a prosecutor say, how did you feel at that point? How are you feeling then? How do you feel about this now? How has this impacted you? And you'll hear numerous times how the complainant will say they were traumatized, they were violated, they felt gross, they felt sick, all this stuff. And the accused...
They need therapy.
Yeah, and the accused, what are they supposed to say? I think it's extremely important for an accused to
remember they're a human being too.
To express how it's impacted them.
Yeah.
And clients will say...
Because people do get falsely accused.
100%.
And it destroys their lives sometimes.
As we've said, being charged with a sexual assault offense is life-altering. As is many charges, but this particularly, depending on your personal circumstances, this is absolutely life-altering. So I find it vital when we're examining a client to end with some sort of emotive element related to the client. And also, it's not bad if the client is nervous. It's not bad if they're showing emotion. It's not bad if they're shaking. It's not bad if they're f***ing crying.
I can't believe how often I cry when our guys get acquitted. I was like...
Well, it's we're
I'm such a girl.
We're
such a girl.
No, we're invested with the case. We live and sleep with the case, and
I care about them so much.
We live it with them. So there is this tremendous relief at the end when there's the right decision for the right reasons, and then you just it's
really
an emotional response, and you can see in the clients. You can see in the clients the relief that comes out.
This last one I was totally cool until his mom cried, and then I was crying.
Yeah, this was a case we had last last week where we got the judgment right away.
Such a girl.
Well, everybody was crying, everybody was emotional at the end, and you could see
That's how much we care about our clients.
I know, but there are other good lawyers who care about their clients too. I mean, we're emotive, but if you're a good defense lawyer, you're living and breathing it.
You cried when you went home, right?
I cry as I'm drafting the bill. I should have charged more. No, but so I want to get across that when we go through these 5 points, I think what's also important would be number 6 when we talk about, 5 is...
You get a bonus.
I think it's important for a person right up front to start thinking ultimately about how they're going to present to a court at the time of trial. So, when you're talking about item 2, which is documenting, item 5, understanding your case, and as how we have our own particular process with clients who provide us with these timelines or chronologies, number 6 would also be sort of a compilation. Think a little bit, start thinking about what and how you're going to present yourself later on to a court. And that comes with your cooperation with your lawyer, but it's something important to think about.
Well, that goes into something I kind of brought up earlier, is keep yourself healthy. Because, so many people...
Actually, that's a really good point. Let's make that number 7.
People so often let their health deteriorate because of the stress on them. And, it may seem like, hard to do or whatever, but keeping yourself healthy goes to your mental health, your physical health. All of it works together again. And it's like if you go into court after, and it usually takes about 2 years to get there to your trial, and if you let your health go to waste for 2 years, you're not going to look good. You're not going to present well, and the best revenge is looking good. Keep yourself healthy.
So a client today said to me, "I'm feeling better, and I remember you said to me when I first met you, time's on your side." Yeah. Many people go, "Oh my God, it's going to take me a year or two to get to trial. I want this over as soon as possible." Of course you do. Of course you do. But that's not the time to do it, because you're emotionally distraught. You're not in the best space. You haven't thought about everything through. Time is on your side.
Yeah, she said, can you imagine if you'd had to testify when you first got charged? Would have been a nightmare. Disaster. Would have been a nightmare.
Yeah, you need time to acclimate. The human condition is really quite interesting. In spite of the challenge that comes before you, humans find a new equilibrium. They find a new normalcy, and they get there. And it's very important for people to try and continue to work, to try and continue to exercise, to try and continue to have activities with their family, to try and live as normal a life as possible, because that will stabilize them, and that will ultimately, at the end of the day, make them a far better witness and mount a far stronger defense. And it's funny that somebody just said to me today, you were right. And they're now in a much better space to be able to testify. And that's so important. As much as you want to get it over with as early as possible, it takes time. And if you're hiring a lawyer who is specialized in the area, they're not going to be available next week for a trial. It's going to take time. And you want...
Embrace it.
And like I've said, putting together defense, it's like...
Getting it right is more important than getting it fast.
It's like birthing a defense. You've got it it takes time to develop it and to read it and to understand it and to work with the client and come up with that narrative and get all the nuances together. And then at the right point, the person will be emotionally stable enough to be able to... They'll still be sad. They'll still be maybe crying. They'll still be nervous in the stand, but they are definitely 100% better. And when some clients have said to us, I can't work, I can't do this, those were the most difficult clients to work with. And ultimately, some of them we had to part ways with because they were just not able to hack it. Mm-hmm. And things did not go well for them. If
they can't speak for themselves, we can't do it. So,
we'd love to climb into their heads.
We can't testify for you.
As much as I'd love to climb in the brain of the person who's testifying, I can't. They're all on their own. I mean, and when they're in the stand, and if there's an answer, they can't look to us and go, "Is that okay?" "Yeah, sure, it's fine." "No, don't say that." I mean, we can't do that, right? They got to be able to testify.
So the reality is, can we break it down into 5 things that you need to know? Well, we did our best.
I think 7 was good. Because I think keeping healthy, I think keeping physically and mentally healthy is important.
Every case is so unique in the end. All we can do is, just say, be aware of the issues. We tried to put it into a top 5.
What minute? More information is better than less. So that's one of the other points that's in all this. Make sure you understand everything and you work with your lawyers on that. Now I'll clink.
All right.
Good night, everybody.
There you go.
So we're going to do
Don't
pillow
forget
talk.
to like, comment. Apparently somebody doesn't like people to comment.
Doesn't matter. Don't forget to like, comment,
subscribe, share, hit notifications.
and send us the comments and questions so we can touch on ideas that you find most
We do
interesting.
actually read them.
We do. I get emails. We get comments. We love it. Thank you. Have a good night, everybody.